Welcome. Today we're going to discuss a case that the Supreme Court decided earlier this year, Romag Fasteners versus Fossil. My name is Scott Slavick. I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, or searching and clearing new global brands on a rush timeline, or reviewing new marketing programs, or advising on risks with respect to social media marketing, I'm happy to help. The case I'll be going over today is Romag Fasteners versus Fossil. This case arose out of a lawsuit brought by Romag Fasteners against Fossil for trademark infringement. As one might conclude from its name, Romag Fasteners sells magnetic snap fasteners. Fossil sells fashion accessories including handbags and small leather goods. In 2002, Romag Fasteners and Fossil signed an agreement to use Romag's fasteners in Fossil's leather goods. Later, Romag discovered that factories in China making Fossil products had been using counterfeit Romag fasteners bearing the Romag mark. Romag sued Fossil pursuant to Section 35 of the Lanham Act, which provides that once a defendant is found to infringe a trademark, the plaintiff may recover, among other damages, the defendant's profits derived from the infringement. The statute further provides that this award must be made subject to the principles of equity. Because of this, there had been disagreement among circuit courts about whether a defendant's willfulness is merely a factor to consider or a necessary prerequisite in whether an award of profits should be made. Because of this disagreement, a jury found in favor of Romag on the question of infringement, but also concluded that Fossil had not acted willfully when it sold its products incorporating counterfeit fasteners. Because the jury did not find Fossil's actions to be willful, the district court did not award Fossil's profits to Romag. This judgment was eventually appealed to the Supreme Court, where the two companies argued over whether an infringement must be willful in order to merit an award for the defendant's profits. In their argument, attorneys for Romag argued two main points. First, they argued that Fossil had infringed on their client's trademark, knowingly adopting and using the Romag mark without Romag's consent. Second, the attorneys argued that Section 35 of the Lanham Act allowed for the recovery of damages caused by Fossil's trademark infringement. According to the provisions of the statute, they argued that Romag should be awarded Fossil's profits from the trademark infringement. In response to Romag's arguments, Fossil's attorneys maintained that Fossil had unknowingly and unwillfully violated Romag's trademark. They then referred to the specific wording of the Lanham Act, requiring that damages be subject to the principles of equity. These principles of equity, they argued, required that damages only be awarded if an actor engages in conduct with the intention of causing confusion or deception. Because Fossil had not willfully attempted to infringe on Romag's trademark, Fossil's attorneys argued that Fossil was not covered under Section 35 of the Lanham Act and thus did not need to pay out its profits to Romag. The Supreme Court sided with Romag. The opinion, delivered by Justice Gorsuch, ruled that while a trademark defendant's mental state is a highly important consideration in determining whether an award of profits is appropriate, a finding of willfulness is not an inflexible precondition to such an award. In reaching that conclusion, the court analyzed other portions of the Lanham Act that use the term willfulness and related terms and went through the historic case law surrounding profit awards in trademark cases. The court observed that because the Lanham Act exhibits considerable care with different mental states, including willfulness, the absence of any such standard in the provision before the court was telling that willfulness should not be a strict prerequisite to profit awards. As for its examination of historic case law, the court found that it was far from clear whether trademark law historically required a showing of willfulness before allowing a profits remedy. So there was no need to reach such a requirement into the meaning of the principles of equity in Section 35 of the Lanham Act. In many people's minds, the question the Supreme Court answered here was one of the most impactful, divided, and unresolved issues in the interpretation of the Lanham Act. With its resolution, generally trademark infringement plaintiffs will have more leeway to claim an award of defendants' profits, raising the stakes for all parties involved. A significant caveat, however, is that the court also maintained that a defendant's mental state, i.e., was the infringement willful, innocent, or something in between, is still highly important. Even with this lowered barrier, obtaining an award of defendant's profits will likely still prove at best to be a difficult hurdle for most plaintiffs. Given this, there are a number of questions that we can consider looking forward. First, will courts see a spike in infringement lawsuits and huge awards? Before this ruling, some courts had only granted such disgorgements of profits in cases where a defendant had acted willfully, but the Supreme Court called that an inflexible precondition that Congress didn't write into the text of the Lanham Act. This decision will make it easier to win money in trademark cases, meaning that some companies may be more incentivized to sue for damages pursuant to trademark infringement. Second, and in a similar vein, will raising the stakes lead to more trials or more settlements? My guess is that it will lead to earlier objective assessment of the strength of each side's case and more reliance on well-designed survey evidence. Finally, although the ruling seems novel, how much of an effect will it really have, and will that effect be primarily procedural or substantive? Much of the country has already been operating under the approach endorsed by the Supreme Court. And while the important Second and Ninth Circuits imposed the hard willfulness requirement, many of the nation's other courts did not. Ahead of this ruling, a common tactic for defendants in trademark cases had been to quickly seek dismissal or summary judgment on the issue of willfulness. That way, they could establish that a plaintiff would not recover any significant money from the case. These types of motions will now be rare, and jury trials will be far more common, leading some to believe that the effects of this ruling will be more procedural than substantive. Still, until more of these cases are argued, we cannot know what the outcome of this ruling will be. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.